Welcome back to City Education, your home for knowledge in all forms, shapes, and sizes. Now, we all know that South Africa's constitution is one of the few in the world that makes socio-economic rights fully justiciable. This was a radical break from the past, designed to confront the deep inequalities left by apartheid.
So,
in today's video, we'll be going deeper into social economic rights in South Africa and the Constitution. Let's get into it.
Now,
Economic rights are at the heart of South Africa's constitutional project of transformation. They go beyond traditional civil and political rights, recognizing that true freedom is impossible without access to basic necessities of life. We find them in sections 26 to 29 of the Constitution, and they include the right to housing, the right to health care, food, water, and social security, as well as the right to education. Now, together, they form the foundation of a society that seeks to redress past injustices and guarantee that dignity, equality, and freedom are not just ideas, but lived realities. Now, these rights are transformative in purpose. They aim not only to provide social welfare, but also to restructure society by addressing the extreme inequalities left by apartheid. This is why Section 7, subsection 2 of the Constitution requires that the state respects, protects, promote, and fulfill all rights in the Bill of Rights. Importantly, these rights are justiciable, meaning they can be enforced in court. This was controversial at first, as critics argued courts lack the truth to adjudicate on matters of policy and budget. But the Constitutional Court has repeatedly affirmed that social economic rights are not abstract promises, they are binding obligations.
as stated
Said above, the Constitution makes it clear, rights are not just promises on paper. Section 7(2) requires the state to respect, protect, promote, and fulfill the rights in the Bill of Rights.
this creates
3 interconnected duties. Firstly, the duty
to respect. This means the state must
not interfere with access people already have. For example, the government cannot arbitrarily evict communities from land or restrict access to healthcare services without justification. In this sense, social economic rights also operate as a shield against harmful state action. Let's move on to the duty to protect.
Now, to protect means the state must
Then third parties,
such as
corporations, landlords, or private actors from undermining people's access spaces.
needs. For instance, the state must regulate landlords
Stop exploitative evictions or companies to prevent environmental damage that threatens health and water security. Finally, the duty to promote and fulfill. Now, to promote and fulfill is the most demanding duty. It requires government to take positive steps, passing laws, allocating budgets, and developing programs to progressively expand access to housing, healthcare, water, social security, and education. This is where the principle of progressive realization and reasonableness becomes central. The state must act proactively with available resources to address both immediate and long-term needs. Now, these duties are not abstract. South African courts have enforced them in real cases, such as in the Grootboom case, the Treatment Action Campaign case, and the Khosa case. Together, these cases show how the framework of respect, protect, and fulfill translates into lived realities for millions of South Africans. When the Constitutional Court first confronted social economic rights in Grootboom, it faced a critical question. How should courts
courts
review government policies without taking over the role of policymakers? The court's answer was the reasonable standard. Instead of asking, does every individual have a right to housing, health care, or water, the court asked, is the government's overall program reasonable in its design and implementation to progressively realize the rights? Now, when applying the reasonable standards test, the courts consider 4 things. No. 1, context sensitive. This
evaluates
programs in light of South Africa's social and economic realities. No. 2, inclusivity.
this entails that
But policies must prioritize the most vulnerable and marginalized, not just the majority. No. 3,
resource awareness.
This entails that courts must take into account that resources are limited, but at the same time, still expect government to make meaningful progress. Number 4, non-prescriptive. This entails that courts do not dictate exact policies or budgets, but instead, they assess whether the chosen measures are comprehensive, coherent, and capable of realizing rights. In South Africa, courts have rejected the idea of a fixed minimum core of each right, arguing that it would be impossible for judges to determine a universal baseline that applies equally across different provinces, communities, and resources. Instead, the reasonableness test allows flexibility, holding governments accountable while respecting separation of powers. In Grootboom, this meant that a housing policy which completely ignored the plight of people in desperate need was unreasonable.
Section 26
It does not guarantee housing on demand, but it does require the state's programs to provide short-term relief as part of a broader strategy. Now let's dive into the fruit bomb case. The citation is Government of the Republic of South Africa versus
Grootboom.
This is the case that laid the foundation.
Miss Irene
Grootboom and her community, evicted from private land, were left homeless. The court held that the housing program was unreasonable because it ignored people in desperate need of temporary shelter. This case introduced the reasonableness test, which requires the state to adopt a comprehensive, coordinated housing plan that includes both long-term development and emergency relief. The decision was groundbreaking because it confirmed socio-economic rights are justiciable and enforceable in court. In another case of Minister of Health versus Treatment Action Campaign, the court considered the government's restriction of the drug nevirapine, which prevented mother-to-child transmission of HIV through a handful of pilot sites. The court found that this policy was unreasonable. Unlike in crude oil, it would further, ordering governments to remove the barriers and permit nationwide access.
This case
So that the court would intervene directly when an unreasonable policy endangered lives and when the remedy was feasible. Moving on, in the case of Khosa versus Minister of Social Development. Here, the courts dealt with actual physical harms. Permanent residents were excluded from receiving benefits, even though they lived, worked, and paid taxes in South Africa. The court ruled that the exclusion was unreasonable and unfairly discriminatory. Social economic rights apply to everyone in the Constitution, not only citizens. This is reinforced that inclusivity and equality are at the core of the reasonableness standard. Moving on, in the case of Mazibuko versus City of Johannesburg, the court considered whether the city's free water allocation, 25 liters per person per day, was constitutionally adequate. The court declined to set a fixed amount of free water. It held that determining the content of social economic rights is primarily the role of the legislature and executive. The court's task is to ensure the policy is reasonable, not to micromanage government choices. This case illustrates the cost differentiation side, reinforcing that it would not act as a super legislature. And finally, in Marshangu versus Minister of Labor, the court confronted the exclusion of domestic workers from the Compensation for Occupational Injuries and Disease Act. It ruled thus unconstitutional, holding that excluding a workforce made up of largely black women violated both equality and the right to social security. This case emphasized the protective duty of the state, which is to ensure that legislation does not leave vulnerable groups unprotected. You see what from Grootboom to Treatment Action Campaign, from Khosa to Mazibuko and Masango, these cases show the evolving face of social economic rights, sometimes differential, sometimes interventionist, but always insisting that government programs must be reasonable and responsive to the needs of the most found group. One of the most important debates
in socio-economic
rights is the
clash between
two models, the minimum core approach and the reasonableness standard. In international law, particularly under the United Nations Committee on Economic, Social, and Cultural Rights, the idea of minimum core obligation
essential.
ignores
that each socio-economic
democrat has a baseline, a non-negotiable floor of provision, which states must guaranteed immediately regardless of resources. For example, everyone has a right to at least basic shelter, food, and essential health care. In contrast, South Africa's constitutional court chose a different path. In Grootboom, as already established,
it explicitly
he rejected the minimum core as a constitutional standard. Why? The court gave 3 reasons. Firstly, institutional limits, which entails that the courts do not have the expertise or data to determine what the minimum level of each right should be. Number 2, separation of powers. Here it was outlined that certain detailed minimums risks intruding into policy-making role of the executive and legislature. Finally, resource variability, which means what might be enforceable in one province could be impossible in another. Now these are the 3 reasons South Africa chose the reasonable test instead of the minimum core approach. Now, while the reasonable approach respects constitutional boundaries, it risks being too differential, leaving urgent needs unmet when courts avoid defining concrete entitlements. The tension between judicial restraints and social justice runs through the heart of South Africa's socio-economic rights jurisprudence. The minimum code debate asks a difficult question. Should courts guarantee a basic floor of socio-economic rights,
or should they simply
ensure government programs are reasonable? South Africa's courts have consistently chosen the latter. But, as we will see, new cases are starting to challenge this balance. Now, for 2 decades,
the constitutional
court
code insisted
that South Africa's model of socio-economic rights would rest on the reasonableness standard, not a universal minimum core. But recent developments suggest that this balance may be shifting. In January 5, the Pretoria High Court desired Institute of Economic
justice
and another,
this is Minister of Social Development. This case
challenged the COVID-19 social relief of distress grant of 350 rand. The applicants argued that the grant was simply too low to meet even the most basic human needs. The court agreed. It got to stop asking whether the grant policy was reasonable and sound. It went further, calculating what amount was actually needed to cover basic
necessities
and holding that the 350 rand figure fell below this minimum. In doing so, the court effectively engaged with a long-debated idea of minimum co-obligation. The notion that social economic rights guarantee at least a baseline level of provision that government cannot go below. The court ordered the state to make every reasonable effort to adjust the grant to meet this benchmark. For the first time in South African law, a court imposed a substantive standard of
adequacy,
not just
procedural reasonableness. This raises a critical question.
Will the Constitutional Court uphold this reasoning? If it does, South Africa may be entering a new era where socio-economic rights include not only reasonable programs, but also an enforceable minimum floor of dignity. From Kruger to the present, South Africa has pioneered a unique model of social-economic rights.
The reasonable standard.
It has allowed courts to hold government accountable while respecting separation of powers. But the IEG case, Institute of Economic Justice case, suggests a possible turning point, one where dignity demands not only reasonable policies, but also an adequate minimum to ensure survival. The future of social economic rights may be moving closer to where the debate began, which is the minimum core of human dignity. There you have it. South Africa's journey with social economic rights shows the Constitution at work as an engine of transformation. From Kruger to the present, the courts have insisted that government programs be reasonable, inclusive, and responsive to the needs of the most vulnerable. The recent Institute of Economic Justice case signals that the story is still unfolding. At its heart, social economic rights remain a promise of dignity, equality, and justice, a reminder that freedom is more than rights on paper. It is about real access to life's essentials. If you found this video helpful, Don't forget to like, share, and subscribe. And comment so we can engage. This is City Education, your home for education in all forms, shapes, and sizes.